Dating back to the Civil War, when soldiers are needed, conscription or the law drafting men into the military has been the solution. However, debate sparked as questions over citizens' responsibility to fight and right to refuse to kill would divide the nation. These debates began during the Civil War over clauses in the draft's laws allowing the wealthy to avoid service through commutation fees and substitutes. Although having a deficient army could mean losing the war, many refused service for moral and religious reasons, becoming conscientious objectors. Through conscription, governing bodies have asserted that it is the people's responsibility to fight on the front lines, but the right to refuse service has conflicted with this responsibility.
At the start of World War I in Britain, Fenner Brockway and Clifford Allen formed the No Conscription Fellowship. Established in 1914, members of the NCF asserted their right to refuse to kill, arguing it was not their responsibility to fight in any armed conflict. After years of successful campaigns from objectors, including the NCF and Quaker organizations, Parliament decided to include the Conscientious Objection Clause in the Military Service Act, or the law implementing conscription in Britain. The support for the clause in Parliament was overwhelming, with only 36 out of the 600-plus members voting against it. Then, in 1916, after the clause was included in the Military Service Act, objectors were entitled to avoid the draft if they appeared before a tribunal court for moral or religious reasons, with the option to request a partial or full exemption from military duties. However, most tribunals held a bias for the draft, believing it was a citizen's responsibility to uphold national security, resulting in few objectors receiving non-combatant status. Over 16,000 eligible men stood as conscientious objectors, while Britain's military program used conscription during the First World War. COs were discriminated against for their ideas regarding conscription, for they believed citizens had the right to refuse to kill because the act of killing goes against most religions and challenges basic ethical principles. Those thousands of objectors were met with harsh remarks about their choice, with the media and supporters of the draft labeling objectors as weak, while also releasing propaganda posters making those who refused service appear cowardly. These events ultimately led to the conflict between supporters of the draft composed of some tribunals and draft opposers, including the NCF. This conflict would later arise in multiple countries and time periods, swaying significant legal decisions. Now overseas, in April of 1917, the United States had declared war on Germany. After only receiving around 73,000 men out of the necessary 4 million, it was apparent that some form of conscription would be needed. So, in May of 1917, with the consent of President Woodrow Wilson, Congress had passed the Selective Service Act with the intent to amass a larger army. The Selective Service Act was nearly equivalent to Britain's Military Service Act, except it had no objection clause and provided no way to avoid military service legally. As a result, the act was met with harsh criticism. Out of the 2.8 million men who were conscripted, 330,000 were labeled as draft deserters after refusing to report for service following their conscription to the U.S. military. Similar to Britain, American conscientious objectors believed they had a right to refuse to kill, and that it was not an American's responsibility to fight in war, demonstrating the shared beliefs of draft opposers worldwide. Those who were draft deserters were subject to a year in prison, further amplifying the conflict between conscientious objectors and draft supporters.
In disagreement with the Selective Service Act's implementation, socialist Charles Schenck made a rather controversial argument about the draft. In 1917, through mailable circulars, he argued it should not be a citizen's responsibility to fight in any armed conflict, and that conscription was a monstrous wrong against humanity in the interest of Wall Street's chosen few. He believed that the Selective Service Act directly violated the 13th Amendment and the permanent abolition of slavery and involuntary servitude. Schenck was tried for violating the Espionage Act, which made obstruction of the war effort illegal. He argued that it was in his First Amendment right to spread his opinions. However, with unanimous decision, Schenck was convicted in the same year, as highlighted by SMU professor Joseph Kobilka, a leading Supreme Court historian.
When a nation is committed to war, it can take actions that further the successful prosecution of that war, because you don't go to war to foster civil liberties per se, you go to war to win a war.
This logic presented by the government was not only attacked by socialist Charles Schenck, but by the whole party itself. Writing to President Woodrow Wilson in 1917 around the same time as the Schenck predicament, activist Jane Addams and Socialist magazine editor Max Eastman argued the Espionage Act had been wrongfully used, limiting the First Amendment right to free speech. The letter read, "Meetings have been broken up, speakers have been arrested, censorship has been exercised not to prevent the transmission of information to enemy countries, but to a free discussion of Americans' own problems and policies." This letter reiterates the fact that informing Americans on socialist viewpoints is not the same as revealing secrets to foreign nations, thus implying that Schenck mailing out those pamphlets should not be punishable by the Espionage Act. Again, the Socialist Party was mainly anti-war, holding beliefs against the working class, risking their lives in battle for the profit of the wealthy, arguing it was not one's responsibility to risk their life for their country. However, this belief conflicted with the conscription laws put in place.
Although the Espionage Act was intended to punish spies, it did not mention the punishment of those who obstructed the war effort. Therefore, Charles Schenck was sentenced to 10 years, which set a precedent of the power Congress had over the people. After requesting an appeal, Schenck was tried again in 1919, and his conviction was upheld as he went to prison along with 16,000 other objectors. United States citizens were disconcerted at the ruling, as this demonstrated the immense power the government held. As World War I ended, the back and forth between draft supporters and opposers would only rage on.
21 years after the end of World War I, the Second World War had begun. Similar to the past, an army draft had been implemented to amass a larger army. In 1940, Franklin Roosevelt signed the Selective Training and Service Act, which was similar to the Selective Service Act, except for the fact that it is a defensive peacetime draft. In 1941, FDR officially recognized the CPS, or Civilian Public Service Program, providing COs with service alternatives to war. Those in the CPS engage in tasks deemed of national importance, including pest control, trail building, and even forest fire prevention. While chaos ensued during World War II, the draft had faced much less opposition than World War I, which could partially be a result of the CPS program. After the bombing of Hiroshima and Nagasaki in 1945, the Axis powers surrendered, marking the end of the Second World War. However, the victories for conscientious objectors would not stop at World War II.
As the Korean War broke out after North Korea stormed their southern counterpart, President Truman, alongside Congress, responded by enacting the Universal Military Service and Training Act of 1951, requiring all men of ages 18 to 26 to register for the military draft. From June of 1951 to 1953, 1.5 million men were drafted into the military. Similar to previous wars, in America, exemptions were given out to conscientious objectors. However, the exact number of exemptions is unknown. While the draft did not face such visceral responses seen in previous wars, it still marked a period of dissent and criticism from the public. In July of 1953, an armistice was signed, proclaiming that the Korean Peninsula would remain divided, therefore bringing an end to the Korean War. The year was 1955, and war in Vietnam had broken out. As the war raged on, the United States became increasingly more involved until its decision to join the war in 1964. The US had already implemented a very unpopular peacetime draft, and as a result, many objectors received positions that did not involve combat. Many people held the same beliefs as our interviewee, Steve Clements, a conscientious objector who refused to pick up arms during the Vietnam War.
And that's this question of rights and responsibilities. I felt I did have a responsibility to do service. For me, service is something that you do out of your heart and out of your beliefs. And I do think it's important that we do owe our nation some form of service, but they call it, the nickname is to be in the service. Well, I'm not sure that going into another land and oppressing people is service.
Backlash against the draft during the Vietnam War was at an all-time high, with over 60% of Americans believing the draft was unfair, according to a 1967 Harris poll. In response to the United States conscripting over 1.9 million men, protesters burned their draft cards to condemn the program at college campuses across the nation. However, for those who did not want any part in the war, or for those who failed to qualify for exemptions, fleeing to Canada was the only option. In Canada, the Toronto anti-draft program gave counseling and housing to the over 50,000 fleeing objectors.
In the same year of the United States withdrawal in 1973, conscription was abolished after Nixon signed legislation to eliminate the draft. While the Selective Service system remained on standby and still exists to this day, the elimination of the draft was a major win for CEOs. Additionally, signed in 1977 by President Jimmy Carter, Proclamation 4483 pardoned conscientious objectors of all convictions of the Service Act. These instances promised a brighter future for conscientious objectors, and while the conflict may have died down, it was certainly not over. More than 100 years after Britain's conscientious objectors first earned the right to refuse to kill, the conflict over conscription continues. Now in Ukraine, a conscription program that has been present since 2014 is in action during its conflict with Russia. Despite previously implementing a CO clause, martial law now suppresses the right to refuse to kill in Ukraine, similar to the previously mentioned conflicts. This conflict revolves around multiple perspectives, as supporters argue wars were able to be fought with a draft. However, from a soldier's point of view, many conscripts start off their lives traumatized from the act of killing in war. To reiterate, the government's implementation of conscription asserted firm beliefs on one's responsibility to serve. However, the people's given right to refuse military service has conflicted with this responsibility. The conscription controversy has forever altered history, cementing its legacy as one of the largest clashes on the power of conscience.